There are two kinds of people who walk into a forest. The first kind understands, on some level that does not require articulation, that they are entering something that has its own rules and its own rhythms, and that their presence in it is conditional on the weather, on the terrain, on the season, and on whether the land belongs to someone who has chosen to allow their presence. This kind of person walks quietly, pays attention, and leaves without expecting anything to have changed on their behalf. The second kind walks into a forest and sees a recreational amenity, an extension of whatever they believe their lifestyle entitles them to, a space whose beauty they have somehow concluded was arranged for their specific use. This kind of person does not pay attention to the same things the first kind does. They do not read signs. They do not look at property lines. They do not consider hunting seasons. Sandra Overton was the second kind of person, and she had been walking her two golden retrievers through my forest trail for 2 years before she stood in front of my barn in late October and learned, in a way she would not soon forget, what deer season in northern Wisconsin means for people who are walking in someone else's private timber on the opening morning of the 9-day gun season without permission or knowledge of who else might be in those woods. My name is Walt Carrigan. I am 61 years old. I own 218 acres of mixed hardwood and conifer timber in Sawyer County, Wisconsin, that I inherited from my uncle in 2009 and that I have managed as a working timber and hunting property ever since. I am not a full-time farmer or forester. I am a retired mechanical engineer who winters in Milwaukee and spends April through November in northern Wisconsin, and the property management is the work I do with my time when I am up here. I log selectively, I manage the white-tailed deer population through a disciplined hunting program, I maintain the trail system that runs through the timber for my own use, and for the use of the hunting club members who lease my hunting rights each fall. The trails are well-marked, well-maintained, and on private property that is posted with orange no trespassing signs at every trail entrance and at 50-yard intervals along every boundary, as Wisconsin law requires for a posted property. The development that matters to this story is Clearwater Pines, a 40-home HOA community built on the western edge of my property in 2004, 17 years before this story begins, on land that was sold by a previous owner of the adjacent parcel rather than from my holdings. Clearwater Pines residents have their own common areas, their own walking paths through a managed natural area maintained by the HOA, and their own lake access on a small recreational lake to the south of the development. What they do not have, and what has never been represented to them in any marketing material or deed document that I have been able to find, is access to my timber. My trail system begins at a point where an old logging road crosses from my property into what is now the Clearwater Pines western boundary. There is a gate at this crossing, a wooden gate I installed in 2011, and the gate has been locked with a padlock since 2011, because in 2011 I had my first experience with Clearwater Pines residents walking their dogs through my timber under the apparent impression that the logging road was a community trail. I put up the gate, I put up the signs, and for the following several years the situation was stable. Sandra Overton had moved into Clearwater Pines in 2019 and had apparently decided, upon discovering the logging road at the western edge of the development, that the gate and the signs were bureaucratic obstacles rather than meaningful communications. She had discovered, through persistence rather than tools, that the gate's latch mechanism had developed a fault in 2020 that allowed it to be opened by lifting and rotating at a specific angle that bypassed the padlock's engagement. The padlock remained on the gate. The padlock was technically locked, but the latch could be defeated without touching the padlock, which Sandra had figured out and had subsequently been using to access my trail system with her two golden retrievers approximately 3 times per week. I discovered this in the late summer of 2021 through 2 means. First, I found dog tracks on my trail system in places that did not correspond to any of my hunting club members' dogs. My club members' access was logged, and I knew which dogs were on my property. Second, a member of my hunting club named Phil Garner, who is a retired forester with 40 years of professional experience reading disturbed ground and trail evidence, pointed out on a scouting walk in August that there were fresh human footprints on the East Trail that did not belong to any of the four of us who had been on the property that week. The prints were from a running shoe rather than a boot, which distinguished them clearly from anyone in my club. I fixed the gate latch in September and added a secondary lock, a cable lock through the gate's lower rail that required two separate unlocking operations rather than one. I also installed a camera on the gate post. The camera captured Sandra defeating the original latch mechanism on her first attempt after I fixed it, which told me she had practiced the motion enough to try it immediately rather than discovering the fix incrementally. She encountered the secondary cable lock and stood at the gate for approximately 2 minutes and then left without entering. She came back the next day and tried again. Same result. She came back a third time 2 days later. Same result. 3 attempts in 5 days, and then she stopped trying, which I read as either giving up or planning. She was planning. The HOA Board of Clearwater Pines received a formal request from Sandra in October 2021, asking the board to formally establish that the logging road at the western boundary was a community access trail. Her argument, in a written letter that the board forwarded to me through the HOA management company as a courtesy notification, was that the trail had been used by community residents for recreational purposes for multiple years, and that this use had established a prescriptive easement right that the HOA should formally recognize and assert. I read that letter, and then I called a real estate attorney named Helen Voss, who had handled a timber sale for me 3 years earlier and who knew my property's documentation well. I read her the relevant sections. She said, "Walt, prescriptive easement in Wisconsin requires open, hostile, exclusive, and continuous use for 20 years. The community has existed for 17 years, not 20. The use she's describing is at most 2 years, not 20. There is no prescriptive easement." I said I knew. I said what I was more concerned about was the HOA formally adopting the position, because once an institution adopts a position, it becomes harder to walk back, even when the position is wrong. Helen said, "Then you need to respond to the board formally and clearly before they vote on anything." She drafted a response letter for me. The letter went to the HOA board and the management company within the week. The board, to their credit, did not act on Sandra's request. The board president, a man named Alan Griggs, who had been in the position for 3 years and who ran a procedurally careful meeting, wrote back to both Sandra and me acknowledging that the question of trail access was a legal matter outside the HOA's authority to resolve, and that the HOA had no basis for establishing community access rights on adjacent private property. He said the board was not in a position to assert prescriptive easement rights on behalf of residents, and that any resident who believed they had individual access rights was welcome to consult an attorney. Sandra consulted an attorney. Her attorney sent Helen a letter asserting prescriptive easement on Sandra's individual behalf, not the HOA's behalf, based on 2 years of personal use. Helen sent a response citing the 20-year requirement under Wisconsin Statute 893.28 and noting that 2 years of documented use fell approximately 18 years short of the legal threshold. Sandra's attorney did not respond further, which suggested he had told her what the law said and she had not liked the answer. I thought that was the end of it. I was wrong. Sandra could not walk the trail through the gate. She had access to the trail from a different direction. I discovered this in early October. My East Trail, which ran through the interior of the timber and connected to several deer stands my club used in the fall, had a section that passed within 40 feet of a county road right-of-way on its eastern end. The right-of-way had a small parking pull-off that county road users sometimes used for fishing access to a creek that ran along the road. Sandra had apparently driven to this pull-off, parked her car, and walked from the county road pull-off onto my timber by crossing a section of property boundary that was posted, but that did not have a physical barrier because it bordered a county road and posting signs is the legal posting mechanism, not physical fencing. She was accessing my property from the east end of the trail while the gate on the west end remained locked. She was, by accessing my property this way, committing trespass. There was no ambiguity about this. my property was posted. The entry point from the county road pull-off was posted. She had been told, through Helen's letters, that she had no access rights to my property. She was walking her dogs on my posted private timber. I documented this. Phil Garner walked the east boundary with me and found the entry point, a worn path from the pull-off through the posted boundary, with dog tracks consistent with 2 large dogs. I installed a camera at the boundary point. Over the following 2 weeks, the camera captured Sandra entering my property from the county road pull-off on 7 separate occasions, each time crossing visibly posted no trespassing signs, each time with 2 golden retrievers on leash. I had 7 time-stamped videos of trespass on posted property. I called Helen. She said file the civil trespass complaint and simultaneously notify the Sawyer County Sheriff. I did both. The sheriff's deputy who responded was a man named Craig Vollmer, who had been working in rural Sawyer County for 18 years and who, when I described the situation, said, "Mr. Carrigan, I'm familiar with this particular access road question. We've had calls about this stretch before." He reviewed the camera footage on my phone. He said, "She's crossing a posted line." I said yes. He said, "I'll make contact with her and issue a formal trespass warning. After the warning, any further entry is a criminal trespass charge." I said I appreciated the response. Craig issued the warning the following day. He called me afterward and said Sandra had told him she had been told by a neighbor that the trail was public access. He said he had explained to her that it was not, that it was posted private property, that 2 separate attorneys had confirmed she had no access rights, and that any further entry after this warning would result in a citation and potential criminal charge. She did not enter my property the following week, or the week after. I thought, again, that the situation had resolved. Opening day of Wisconsin gun deer season is the Saturday before Thanksgiving. I am precise about this because the date matters enormously to what happened next. Every year, my hunting club arrives the Thursday before opening day to set up stands, scout final positions, and prepare for the 9-day season that is the most important hunting event of the Wisconsin calendar. The woods are orange-vested and orange-posted. Safety orange is everywhere. The sounds of the day before opening morning are the specific sounds of serious hunters preparing, the click of safety checks, the quiet conversations about who is going where, the final review of property boundaries and stand locations. Anyone who grew up in Wisconsin rural culture or who has any familiarity with deer season knows exactly what the preseason Thursday looks and sounds like. It is unmistakable. On that Thursday morning, at 8:47, Sandra Overton walked through the county road pull-off boundary with her 2 golden retrievers. The camera captured it. Phil Garner was 60 yards from the boundary checking a trail camera when Sandra and the dogs came through the tree line. Phil told me afterward that his first reaction was disbelief, not at the trespass, which he had been briefed on, but at the timing. He said, "Walt, she walked in 2 days before opening morning. The woods are full of hunters in orange. There are firearms present." He said, "She was in street clothes with 2 yellow dogs." I want to be clear about safety. A hunting property on the Thursday before deer season has hunters moving through it, has firearm safety protocols in place, and has every person in orange precisely because the orange is the safety system. A person entering a posted private hunting property in street clothes with 2 large yellow dogs, without permission, without knowledge of where hunters and stands are located, is creating a genuine safety situation, not because any of the hunters would fail to identify a target before shooting, but because the presence of an unauthorized, unplanned person and 2 dogs in the woods introduces chaos into a carefully managed safety environment. Dogs run. Dogs flush deer at unexpected angles. Hunters are alert and attentive and tracking movement. The introduction of unknown variables is the thing that hunting safety protocols are designed to prevent, and Sandra's entry was exactly that kind of introduction. Phil immediately and calmly walked towards Sandra, identified himself as the property manager's representative, and told her she needed to leave the property immediately. He told her the property was a working hunting property with armed hunters present, that she had entered on 2 days before the opening of gun deer season, and that her presence and her dog's presence were a safety concern that required her immediate departure. He said she looked at him and said, I've been walking this trail for years and no one has ever had a problem with it. He said he explained, again, that the property was private, posted, and that she had received a formal trespass warning from the Sawyer County Sheriff's Department. He said she looked at the orange vests on 3 hunters visible from where they were standing and then appeared to understand, for the first time in a visceral rather than theoretical way, exactly where she had walked. She left. Phil walked her to the boundary and watched her return to her car at the county road pull-off. I called Craig Vollmer. Craig Vollmer came out that afternoon. He reviewed Phil's account, reviewed the camera footage of the morning's entry, and confirmed that the entry constituted criminal trespass under Wisconsin Statute 943.13, entry onto posted private property without consent following a formal trespass warning. The formal warning had been issued. The entry had occurred after the warning. The statute was clear. Craig issued a citation. Sandra was not on my property when Craig arrived, but the camera footage was sufficient documentation, and Craig said he would follow up directly with her. He called me the following evening. He said Sandra had received the citation and had said she had not realized the guns would be out already. Craig had explained to her that Thursday, before opening Saturday, was standard gun deer season preparation, that the property she had entered was a permitted hunting property with an active hunting club and multiple hunters on site, and that her entry had created the precise kind of unmanaged variable that hunting safety protocols were designed to prevent. He said she had been quiet for a period of time and then had asked whether she was going to be criminally charged. Craig said the citation was a civil forfeiture rather than a criminal charge, but that a second post-warning entry would be charged criminally. He said she had understood. The civil citation carried a fine of $223 under Wisconsin Statute 943.13. Sandra paid it. Helen Voss filed the civil trespass complaint simultaneously, seeking injunctive relief, specifically a court order prohibiting Sandra from entering my property and establishing a legal record of the trespass pattern. The hearing was scheduled for February. What happened between October and February was, in many ways, the more interesting part of the story. Sandra did not return to my property. The citation and the hunting season context had apparently communicated something that 2 years of gate locks, attorney letters, and a sheriff's warning had not fully communicated, which was that her belief about the trail's status was disconnected from reality in ways that had real-world consequences. But she did not simply accept the situation. She went back to the HOA board. Her second approach to the board was different from the first. The first had been a formal request to assert prescriptive easement rights. The second was a petition. She had gathered signatures from 17 Clearwater Pines residents who, according to the petition text, strongly believe that the historic trail access at the western boundary represents a community amenity that deserves formal protection. The petition was organized, the language was careful, and it was delivered to the board with a cover letter noting the importance of outdoor recreation access for the community's quality of life. Alan Griggs called me the day after the petition was delivered. He said, "Walt, I want you to know before I respond to this that the board's legal position has not changed. We have no authority to establish access rights on your property." I said I appreciated the call. He said, 17 signatures is a significant portion of the community and I can't ignore the petition. But the board's response is going to be the same as before, that this is a private property matter that the HOA cannot resolve. He said, "I thought you should know about the petition because it may result in individual residents contacting you directly." I said I appreciated the advance notice. He was right. I received 4 direct contacts in the following 2 weeks, emails from residents whose signatures were on the petition, asking whether I would consider a formal trail access arrangement. The emails were generally polite. One was from a couple with 3 young children who said the trail was the only forested walking area accessible from the development without driving, which I could not help but find genuinely sympathetic. One was from a retired couple who said they had been walking the trail for years and had not realized it was private. One was from a man who said he thought there was some arrangement between the previous landowner and the development that he had been told about when he bought his house, which was the first I had heard of this claim and which sent me back to my own title history. The title history search produced nothing supporting such an arrangement. No easement, no license agreement, no recorded instrument of any kind that mentioned any access agreement between any prior landowner and the Clearwater Pines development. I sent Helen the title search results, and she confirmed there was nothing there. The February hearing on Helen's injunction motion was notable for one specific development. Sandra's attorney, she had retained a new one, replacing the first who had apparently delivered unwelcome news, argued that the trail's use by community residents over 17 years constituted the kind of community reliance that equity courts sometimes considered when evaluating injunctive relief. Helen responded that equity arguments did not override statutory property rights, that there was no recorded easement, that the prescriptive easement argument had been properly rejected, and that the court's role was to enforce the law as written rather than to substitute equitable preferences for statutory property rights. The judge agreed with Helen. The injunction was granted. Sandra Overton was formally prohibited from entering Walt Carrigan's property, and the order was served on her personally and recorded in Sawyer County's civil court records. I also won a modest civil damages award, $412, reflecting the 7 documented trespass incidents at a nominal per-incident rate, which was less than Helen's filing fee, but which was not the point. The point was the recorded order, which established the legal history in a form that would survive any future change in personnel or any future attempt to relitigate the access question. The HOA situation took a different and more interesting turn in the spring. I had been thinking, since the polite email from the couple with 3 children, about the question of whether there was a version of a formal access arrangement that would work, that would serve the genuine recreational need the community had while protecting my property rights, my hunting operation, and my legal position. It was the kind of question I had not wanted to consider while the dispute was active and adversarial, but with the injunction in place and the situation legally resolved, I could think about it more calmly. I called Alan Griggs in April and told him I was open to discussing a formal seasonal access arrangement if the board was interested. He said they were very interested. I said I wanted Helen involved in drafting any agreement. He said, of course. The arrangement that Helen drafted and that the board and I eventually executed was a seasonal trail access license with the following terms. The license was limited to 2 sections of trail, not the full trail system, and specifically not any section within a quarter mile of any established deer stand location. The license was limited to non-hunting season, specifically April 15 through September 30, which excluded the full gun deer season, the bow season, and the turkey season. The license required all users to be registered with the HOA, to carry a trail permit card issued by the HOA, and to follow specific rules including dogs on leash at all times, no camping, no fires, and no entry after sunset or before sunrise. The license was revocable by me on 30 days written notice for any material breach by any user. The annual license fee was $1,200, paid by the HOA, which I felt was fair for the access granted and which the HOA's board agreed was reasonable. The agreement was recorded as a license, explicitly not an easement, and with specific language confirming that the license created no easement rights and that all fee simple property rights remained entirely with Walt Carrigan. Helen's last note on the draft before I signed it: Walt, this is the right outcome. You've licensed access on your terms in seasons that work for your operation for a fee that respects the value of what you're providing. The people who needed the trail get the trail when they can safely use it. The hunters get the woods when they need them. The documentation is correct and protects your rights completely. I said it had taken longer to get here than it should have. She said, it always does when someone decides they own something they don't own before they talk to the person who does. The first April 15, after the license took effect, I drove out to the county road pull-off to see who was using the East Trail entry, which was now an authorized entry point with a proper license provision, and a small sign the HOA had installed noting the registered trail access requirement. There were 3 cars in the pull-off at 8 in the morning. A couple walking an older lab mix who nodded at me from the tree line. A woman with a running stroller and a small dog on a leash who was clearly going to be brisk and efficient about the whole thing. And a man I recognized from one of the polite emails, the one with the 3 children. He was there with 2 kids in elementary school ages and a smaller one on his back in a carrier, all of them in rubber boots, heading into the timber with the happy purposefulness of children who have been told there are mushrooms to find. I sat in my truck for a few minutes and watched the entry point. The signs were up. The license was recorded. The hunting season was 8 months away. The timber was what timber is in April in northern Wisconsin, still bare at the canopy level, but with the green ground cover beginning at the base of everything, and the light through the birch stands at that low spring angle that is specific to the latitude and specific to the season. Phil Garner pulled in behind me and got out of his truck and stood beside mine and said, "You watching them?" I said yes. He said, "Feels different than the October situation." I said yes. He said, "Same trail, same people." I said, "No, different people, different season, different paperwork." He said, "Paperwork changes things." I said, "Paperwork makes things what they are. Without the paperwork, it's just people in the woods arguing about what's whose." He said, "And with it." I said, "With it, everybody knows what they're doing and why, and they can go home at the end of the day, and none of it has to be relitigated." He said, "How's the agreement working?" I said it was working. I said the registration system was running through the HOA, the permit cards were being issued, the rules were being followed. I said I had not had a single problem since April 15 and did not expect one, because the people using the trail under proper license were using it as guests rather than as owners, which was the difference that had always mattered. He looked at the trail entry where the family with the small children had gone in, now empty of people, and returning to its ordinary appearance of a well-worn path disappearing into birch and maple. He said, "You know, Sandra Overton didn't have to make this a fight." I said I knew. He said, "If she had just asked," I said, "she might have gotten a trail access arrangement 2 years earlier, without a trespass warning and a sheriff's citation and an injunction and a civil damages award." He said, "Would you have agreed to it?" I said I did not know. I said probably not immediately, because the hunting season question would have needed to be resolved, and that takes a conversation and some thought. But eventually, if someone had asked as a neighbor rather than demanded as an entitled user of something they had decided was theirs, we would have found a version of what we found. Phil said she found it anyway, just the longer way. I said yes. He said, "The woods are still here either way." I said yes. He said, "That's the thing about timber. It doesn't care how long the argument took." He got back in his truck. I got back in mine. We drove our separate ways back into the property to do the April work that April required. The trail license runs every year now from April 15 to September 30. The hunting season runs from October through the end of December. The two do not overlap and are not intended to. The documentation is recorded. The rights are clear. The timber produces what timber produces. And the people who use it, the hunters in fall and the walkers in spring and summer, use it correctly within the rules that govern their presence, with the knowledge that the land belongs to someone who cares about it and who has organized its use in a way that works for everyone who has a legitimate role in it. That is what property rights are for in the end. Not exclusion for its own sake, but organization, the ability to determine who is in the woods and when and for what purpose, so that the woods can be what they are supposed to be for each of those people without any of them getting in each other's way. The timber stands. The trail is open when it should be open. The stands are unmolested when the season requires it. Everything is documented and everyone knows what they have and what they owe and what the rules are. I do not ask for more than that from any property I am responsible for. It has always been enough.